And we're joined now by Elton Hart Attorney with the University of Johannesburg's Law Clinic to discuss this further. Very good evening to Mr. Hart. Thank you so much for taking the time to speak to us. I'd like to look at the strategic importance of the move taken by the Speaker, Ms. Nosiviwe Mapisa-Nqakula, particularly as the MPA says they see the application as baseless. So in terms of Section 1443 of the Criminal Procedure Act 51 of 1977, is there a reasonable expectation of her being arrested, but more so of her being informed about it?
No, as any other South African, she has got certain rights, and when they want to arrest her, they can use a warrant or they can send out a summons to say to a person, listen, yeah, you need to actually make yourself available on this date. You are being charged with X, Y, and Z. But if there's a warrant, they can, wherever they find you, they can arrest you, and the arrest must be effected by a peace officer. A peace officer can actually execute the warrant. But no way in law can a person who is a person of interest dictate to our law enforcement agencies the way in which they want to be arrested. Because if this application is granted, they say that she wants the court to order that her attorney should be informed when she is comfortable to be arrested. That would set a precedent. Then it means that everybody in South Africa will now use this case as a precedent to say, yes, I'm a person of interest and this is how I want to be arrested. And that can never happen, because that would also limit the abilities of law enforcement agencies to quickly arrest people of interest.
So take us through the process. At what point does one move from being a person of interest to be questioned to a person of interest to be arrested? And is it not reasonable to anticipate that you will be informed of the charges? This is what Nosiviwe Mapisa-Nqakula is saying through her lawyers, that she wants to know what evidence is there that will inform the need to arrest her.
She's now like trying to put the horses before the cart. You cannot dictate to law enforcement agencies how they should investigate crime. They will obviously, if there's a complaint, they will investigate the complaint. And if they're of the view that they now have gathered sufficient evidence in order to actually formalize the claim and put the charge against you, that's when you get actually arrested and the charge is put and you are formally charged. And there are 48 hours after your arrest in order to actually charge you and bring you before a court of law. So that is the stock standard procedure that all law enforcement agencies. Sometimes we hear the story that a person will submit themselves to a police station because they hear there's rumors that they are a person of interest and they might be charged. They bring themselves in and then somehow a summons is issued to say, come to court tomorrow morning at 9 o'clock. And you will be now standing trial for certain things. But that is not a given that it should happen that way. It's sometimes a courtesy that is extended to people that is not seen as a flight risk, that is not seen as maybe a danger to society, and that easily negotiate and sort of speak to the law enforcement agencies to say, listen, yeah, I'm a fixed term employer, I'm work there, and I will come to court, I'll represent myself at the charge office. Then they can do that. And when you are a person of interest, obviously, they will first gather the information. And if they feel like now you move from a person of interest to a person that can be a suspect, then you are brought in for interrogation. And if they feel from that interrogation there's sufficient evidence or you're not cooperating, they can charge you. And then you become now a person that's charged. You become an accused person and you are being brought before court.
So now I want us to take that, the criminal justice system and what happens in terms of the Parliamentary Code of Ethics and Conduct for members. For instance, you saw the committee last year, they were finalizing some of the cases in relation to recommendations that flowed from the Judicial Commission inquiry into allegations of state capture. Would that not have been some form of guidance on what happens, particularly in terms of the integrity of the National Assembly, but also observing the legal rights of the Speaker? Because there are calls now that she must resign or that her summarily taking herself on leave is irregular?
No, if one looks at how the National Assembly works, one needs to also look at the political landscape within the National Assembly. And we know that the ANC currently holds a 2/3 majority. So obviously, I know there was at some stage, there was a probe into the Speaker as to her fitness to hold office as Speaker, and they wanted to have a vote of no confidence. They dropped that investigation. But that probe, that parliamentary inquiry, should not be sort of half inflated or sort of tangled into a criminal investigation, because here we hear that the Hawks is alleging that she's somehow involved in a 2.3 million corruption affair. So the Hawks needs to use the criminal procedure to say, listen, yeah, we're going to gather evidence, and this evidence must be admissible in terms of the law of evidence in a court of law in South Africa, and based on that, we are going to charge her criminally so. But obviously the rules of Parliament and how Parliament conducts its business is a little bit different, because that is like a quasi-judicial process that they follow in Parliament, and it's on a balance of probability, while in the criminal court is beyond reasonable doubt, you need to have evidence. So these two processes, and obviously Parliament, how they do their things, they are not dictated by what's happening in the criminal courts. They must still do their business. If they feel a person is not fit to hold office, they can have that inquiry by a specific committee, a subcommittee, and then they make a recommendation to the National Assembly that votes on these things. And when you come to criminal investigations, if there's a complaint at a police station, then they must investigate, and if they feel they've got enough, they will charge you with a specific crime. And that's the two distinct differences, how these investigations and inquiries sort of work.
That's where I'm taking it, Elton. So it should happen that Nosiviwe Mapisa-Nqakula is arrested, and there is this motion of no confidence in Parliament, basically saying that, you know, somebody who faces such accusations, and this is what some of the opposition parties have been saying, somebody who occupies a position such as that, the weight thereof. So if you are accused of this, if you are arrested for this, is it enough of a framework of reference for Parliament on how to proceed? Or her legal rights, do they still trump that process that will unfold rather?
No, she still has her legal rights, and she can use all remedies in law to actually protect her rights. And Parliament, as an institution, they still have to do an inquiry. And even if they say that now, yes, there's a formal charge that you are charged in the criminal setup of our law, and not necessarily by the probe finding you guilty. If there's a criminal charge, Parliament still needs to go and say, okay, you are criminally charged, but the National Assembly still needs to vote to say, can we pass a vote of no confidence? And that is where numbers now plays a role. And obviously we know the ANC, and she's a deployee of the ANC. They've got numbers on their side. I mean, so many times the motions of no confidence, which was solid and good, based on evidence that was there, but because of the numbers game that's playing out in Parliament, it's not going anywhere. And this is the same thing. If the NEC or the NWC or the branches of the ANC says, but we don't want you guys to vote any other way to get rid of the Speaker, then they're going to vote in favor of the Speaker staying, and then there's nothing you can do. Then you tie down the parliamentary process. The only other thing is then the criminal case that's against her, and then it must be shown beyond reasonable doubt that she was involved in that 2.3 million scandal or charges or the corruption that's leveled against her.
Oh, thank you so much for your time and sharing your thoughts with us, Elton Hart. He is a legal expert speaking to us from Hart Attorneys about what's happening, expected to happen in court tomorrow as the Speaker, Nosiviwe Mapisa-Nqakula, attempts to interdict the impending or possible arrest of her by the NPA.